Hi, welcome to Talking Legal Episodes. I'm Praveen Gautam, your trusted marketing advisor. I help entrepreneurs and enterprises to build the digital brand and monetize it. If you're watching this right now from number of social media channels, including Facebook, YouTube, yes, YouTube as a Talking Legal, or from the LinkedIn, feel free to just give us a thumbs up, like, share, and comment it. Today's episode, we want to talk about a lot of the viewers has been asking actually about the family court consent order. So I have got a special guest today. Let me connect you through Laura. G'day, Laura. How are you?
Hello, Praveen. I'm good, thanks.
That's good. Welcome to the show. It's great to have you today.
Thank you very much. Great to be here.
You bet. Laura, obviously you have been in the industry for more than 15 years, and you have recently joined Law Family Lawyers, which is a proud division of Baker Watt. Can you tell us a little bit about you and to our viewers who are watching this right now?
Okay, so as you said, Praveen, I've been in family law for about 15 years or so, on and off. I did some child protection work as well in Queensland and in Darwin. I'm originally from Melbourne, but I've in family law as well, but I now call Brisbane my home. I've been here for about 3 years. So, yes, that's me in a nutshell.
Beautiful, beautiful. That's great. So let's talk about today's. A lot of our viewers have been asking about, the interesting time, obviously, asking about family court consent orders. So, in a very layman term, what is financial agreement and what is, so can you explain a little bit on that, please?
Okay, sure. So a binding financial agreement is basically a contract. It's a contract between couples that basically ousts the jurisdiction of the family court to make orders in relation to their property between them. Okay, a binding financial agreement can be made before marriage, during marriage, after separation. It applies to de facto couples as well, so before the relation, during and after. Once the agreement has been made, the jurisdiction of the family court ceases to apply. Okay, there are strict rules in relation to how this agreement is drafted. Consent orders, on the other hand, are orders made by the court and agreed to by the parties and approved by the court, and they also include financial and parenting orders. Same for married persons as well as de facto couples. And also there are certain rules that the parties must adhere to in relation to getting those orders through the court.
Okay, that's great. Thank you, Laura. That's really good. But I would imagine as a how it is advantage to entering the financial, there must be some cons, isn't it? I mean, there must be some disadvantage entering. So, would you mind sharing a little bit on that? Is it ideal? In what cases it would be?
Yes, sure. So, yes, there are advantages for entering a binding financial agreement over the consent orders approved by the court. Some of these advantages include that there's no court appearance required for a binding financial agreement. It offers parties a level of security and peace of mind when they separate. That it can implement their joint purpose. For instance, if parties have recently married and one party has had a prior relationship or marriage and they're coming into the new relationship with, say, a property that they want to quarantine or keep out of the property pool in the event that their new relationship fails and they separate. So it's some certainty for couples. There is no court oversight though, okay, so the family court does not get involved in these financial agreements. That could also really be a disadvantage. Also, these financial agreements can set ground rules for parties' future spending, if you like. Yes.
Beautiful. That's great. We have got a viewer here. Say g'day to ABRP Watt for us, will you? G'day, Peter. It's a great time. If there's anything, specific questions you have for Laura, let us know. We're more than happy to deep dive here. So that's good. Let's get into. Can you register a financial agreement then, Laura?
No, unfortunately not. There's no process at the moment to register these financial agreements, which is a little disappointing because, some financial agreements are made, say, today, and, they can last 20, 30 years in the event that parties separate, parties move on, they shift house, lawyers who have the agreements retire. Things do happen in life. But unfortunately, no, not at this stage. There's no requirement to register the agreement.
Okay, that's great. Thank you. I hope that's give you a very clear, idea for our viewers here. Just on that note, then we're curious to know some of the advantage entering into the consent order. You touched on the consent order, so can you explain what are some advantages or disadvantages about entering to the consent order, Laura, please?
Yes, so we talked about the advantages of financial agreements. Some advantages for the consent orders is that there's an application that's filed at the family court, so there is a court oversight in order for them to make the orders. So, and when they look at the proposed agreement of the parties, they don't just rubber stamp the agreement and say, yeah, that's fine. There's an actual process that the court uses, and they have to assess whether the proposed agreement is just and equitable to the parties. So there is some oversight. Also, consent orders include parenting matters, which financial agreements obviously do not. Parties don't need a lawyer in relation to consent orders. They do need a lawyer. Yes, they do need a lawyer in relation to binding financial agreements, and that can obviously be a disadvantage and to some people who can't afford a lawyer. So the binding financial agreements, they need a lawyer because the lawyer has to give them strict and independent legal advice about the binding financial agreement, and there's actually also a solicitor's certificate that the lawyer has to sign saying they've given that advice. So unlike consent orders, as I said, don't need a lawyer.
Yeah. No, yes. Thank you, Laura.
There's also less risk.
Mm-hmm. Yeah. Please. Sure. Sorry, there was.
Just one more thing, Pravin. There's also less risk that the orders will be set aside later if made by consent orders rather than binding financial agreements.
Right. There's a lot of things to grab on, isn't it? Obviously, if you don't have, the legal for someone who is a very basic on the legal. So, guys, if you're just tuning in now, I'm with Laura, senior consultant from Law Family Lawyers, Proud Division of Baker Watt. So, any specific questions in your specific place? So, yeah, feel free to just type or comments. Send the message directly as well to Laura. Her best email is laura@matthewlove.com.au. Yeah, Laura.
Yes.
Okay. So then just on that note, we're curious to know, can the court set aside a financial agreement or a consent orders? What's your thought on that?
Yes, the courts can set aside, and they have set aside binding financial agreements. There's specific sections and things that the court would look at. These things are, for instance, in circumstances of fraud, where a party has hidden an asset, say they've got a bank account they didn't disclose at the time that the other party signed the agreement, and now the other party knows they've got, say, 100,000 in that bank account. It can be set aside that would be a material matter. So the courts will set aside, or most likely set aside, a financial agreement if there has been fraud, non-disclosure of that material fact. They can set aside the agreement if the purpose was to defraud a creditor of the parties, if there's been some unconscionable conduct, some duress, if the agreement is impractical for it to be now carried out, or there has been a material change in the circumstances of a child of the relationship. In relation to consent orders, the criteria is roughly the same with a few differences. It would have to be, in order to set aside a consent order, there has to be some miscarriage of justice, and that would include fraud, duress, things that we talked about, unconscionable conduct, failure to disclose the relevant information, where a person has defaulted in relation to the order, or exceptional circumstances exist in relation to a child of the relationship. But overall, it's much easier to set aside a financial agreement than consent orders. It's harder to set aside consent orders because they've gone through the court system, and the court has made that assessment at the time that it's just and equitable at the time that they've made the orders. That's really the difference.
Okay, so what you're saying is pretty much it is easier to set the court aside financial agreement rather than consent orders. Yeah, that's what you're talking about.
Yes.
All right. I hope that's given a very clear idea to all the viewers who are watching this right now. And obviously, the questions when you talk about legal, especially in family matters, people talk about cost, right? Cost.
Yes.
So obviously, and it depends. What are the costs involved in having lawyers to draft these documents? Are we talking, thousands of dollars, or can you share that, please, Laura?
Well, I can share that. So as I said, you don't need a lawyer to draft the consent orders. Some parties draft consent orders themselves. You can download the consent order kit on the website, the Family Court website. So that clearly would save a lot of parties professional fees, lawyer fees. In relation to a financial agreement, though, parties must see a lawyer, as I said, because the lawyer needs to sign the certificate, and there are strict what we call disclosure requirements. So you need to produce documents or evidence in relation to the party's current financial circumstance. And that costs money for the lawyer to read, include that, and draft the binding financial agreement. So cost to draft consent orders can range. If parties do it themselves, it's really just a filing fee, and that's, I think, set at $170 now. If you get a lawyer to draft the consent orders, that can range between, say, $1,500 to maybe, $3,000 to $4,000. It really depends on how much work is involved and how much property of the parties there are, including super. If there's usually super, and that's part of what we call a division of super splitting order, that may increase the parties' fees a little bit. Cost to draft a financial agreement, it depends on what type of agreement. So if it's, say, before marriage or before a de facto, or during marriage or during de facto, that can sometimes increase the costs. So you could look at, parties need to be aware that a binding financial agreement would probably cost between about $5,000. Some cost even as high as $10,000. It depends on the property of the parties, really. Hope that's helpful.
Thank you, Laura. That gives a bit of ball figure, but we understand every situation is different, and every person is different. Obviously, the relationship and the property and the wealth comes there, including super. So, totally get that. But the ball figure you just get, whether that may be 5K or 10K, so it would be obviously situation different. Now, anything you want to add besides what we have covered up on today's topic, especially family court consents and binding financial agreement, Laura?
No, I just hope that everyone finds this blog helpful, and if they've got any questions, please contact me at Matthew Love, Family Lawyers in Capalaba, and my email address is obviously laura@matthewlove.com.au, so I'm happy to answer any questions.
Beautiful. Thank you so much, Laura. And obviously, you have a national number as well, which is 1300 at legal. So anyone watching this right now from different social media channels, if they have any situation, any specific questions on that matter, so feel free to reach out to Laura and your team, and obviously they specialize on this family matters and family court consents and binding financial agreement. So on that note, thank you so much for your insight, Laura. We hope
Thank
to
you,
see
Praveen.
you. See you in future episodes.
Yes,
And look forward to catching up.
thank you, Praveen. Take care. Bye.
Take care. Bye for now. And thank you, guys. We'll see you in the next episode on Thursday. Yes, 5 p.m. Talking Legal. Bye for now.